Hello and welcome to Uncommon Law, my podcast about true stories from my life experience of over 50 years as a lawyer and trial judge. This is a look at the law from the inside out, stuff they don't teach in law school. This is Judge Rudy Greco, retired Justice of the New York State Supreme Court. Sometimes a judge has to give a difficult litigant exactly what he or she wants. So in 2007, or actually 2013, excuse me, I was elected to New York State Supreme Court. And as a new Supreme Court judge, I was called in to the office of the administrative judge of the Supreme Court in Queens County for a conference on my assignments. And the assignments basically cover two areas. And the first is a physical assignment as to what courtroom and what chambers office space you're going to get. And the second assignment has to do with what part of the court or what nature of your judicial assignment will be. The parts of the court are numbered, and they have different significance. Some of them are trial parts, or general trial parts, so they try all kinds of cases. Some of them are matrimonial parts. Some of them are commercial parts. Some of them are commercial real estate, landlord-tenant parts with businesses and things like that. And, well, you get the picture. There's a number of different assignments. So being a new judge, a newly elected judge, just like anywhere else, you get the worst assignments. And it's sort of like an initiation period that you go through. The senior judges don't want the troublesome parts, and they give them to they give the least favorable quarters and courtrooms, least convenient and the least desirable parts to the new judges. So my administrative judge calls me in and said, well, Rudy, he says, I'll tell you what I would like you to do. I'm going to give you chambers. I'll tell you in a minute, but I want to assign you to a matrimonial part. And I said, whoa, wait a minute. Matrimonial? I have a couple of reasons. I can't stand matrimonials. He said, well, what's the problem? I said, two problems. I hate matrimonials, and I hate matrimonials. That's the second part, okay? So he said, well, why? What's the matter? I said, well, a number of reasons. I said, first of all, my mom and dad got divorced when I was 14, and it was nasty business and left a bad taste in my mouth. Second of all, matrimonial work is highly emotional and carries a lot of responsibility in the case of custody cases. If you're deciding custody, a lot of times between parents you have bad choices. Neither one of them is much good, and you're going to have to decide where the kids are going to go. And it's very distasteful. And I don't want, at this late date in my life, here I am in my 60s, I don't want the responsibility of deciding people's lives in a serious way. Send me to a regular trial part where they're arguing about money, good old-fashioned money, and I can go to sleep at night and I have no problem with any of this stuff. I don't want to deal with criminals anymore. I did that for 22 years in private practice, and I don't want to deal with matrimonials. I did that for the first 5 years of my law practice because just out of financial necessity, you take any case that walks in the door. And I disliked it intensely. It's nasty business. I just don't like it. Why don't you give the matrimonial assignment to the other judge that was elected along with me? He has the same seniority I do. Why don't you give it to him? And he said, well, very simply, he can't handle it. You can. You're in private practice and you did this. You can handle it. I said, oh, that's great. I said, well, I can handle a mop and I can handle a garbage can. Does that mean that I have to mop the floors in the courthouse and I have to lift and collect all the garbage in the courthouse because I can do it? He said, well, I was going to get to that later. I didn't want to talk about that right now, and he started to laugh. So I said, well, what else is going on? He said, well, I want you to do this for 2 years. I said, no, first of all, if you're going to insist that I do this, I'm going to do it for 1 year. Next year, there are judges retiring, and new judges are going to be elected to this court, and they'll have no seniority, and you can give them this assignment and pass it on. I'm not doing this for 2 years. There's no way I'm doing it. Well, the administrative judge himself had been a New York State legislator. He was a state senator for a long time. In fact, he never really practiced in law as such. He was a lawyer and he was very bright, but he was mostly a career politician. And being a member of the New York legislature, he learned the value of compromise. And he saw that I was not moving off my position, and I was adamant. And he also saw the need to have somebody for the coming year, and he saw that I was gonna accede to it if he gave me 1 year. So he compromised. He wasn't happy about it, but he smiled and he said, "Okay, 1 year." He said, "But you're going to go to Long Island City Courthouse." Now, in Queens, Supreme Court on the civil side, there were two courthouses. One of them was a big old Grand Depression-era courthouse in Jamaica, which had about 35 judges and courtrooms. And that was the center of all the action. And then there was this old 1800s vintage French Second Empire courthouse, very picturesque, in Long Island City, which I didn't mind going to. That was nearby anyway, but that was sort of like exile. The judges there were like McHale's Navy. Nobody ever saw them, and it was actually a nice place to practice and stay away from all the nonsense and the confusion that was the main courthouse. So I didn't mind that. That was supposed to be sort of like exile and sort of a form of punishment for or initiation for a new judge, but I didn't mind that at all. I didn't say that, and I said, "Okay, I'll go to Long Island City." He said, "But the reason why you're going to Long Island City is because I'm going to create a bullet part." Now, a bullet part in courthouse jargon means a part that's for trials only. There are no preliminary proceedings. Only cases that go to trial go, and they call it a bullet part because it's fast. You're not going, with any preliminaries. There were three other matrimonial parts in Queens County, and they were conventional parts where the judges would handle the matters from the very, very beginning, from the inception right up until the end, and with all the preliminaries and all the intermediate procedures that went on, discovery and hearings and evidentiary hearings, it's modifications and back and forth negotiations, all sorts of stuff. And he said, the reason I'm going to make it a bullet part is because I have no room in Jamaica Courthouse for a fourth part. And the matrimonial lawyers, all the lawyers who practice only matrimonial law, would really resent having to go for a regular part to Long Island City. But they won't resent it if they're going for a trial, because they know they're going to be committed there for 3 or 4 days, or 5 days, or a week, or 2 weeks, or whatever it is. He said, but if they had to go for a regular part to Long Island City, they wouldn't like it, because they want all the regular parts in one place where they can go to different parts of the court on 3 or 4 different cases before 3 different judges in the same building, and it's convenient and it makes things feasible for them as private practitioners. So you're going to go down to Long Island City, and you have a bullet part, trials only. I said, well, if you insist, I'll do it, but for 1 year. He says, it's a deal. You do it for 1 year, and you're off the hook as far as that's concerned, and we'll get you a regular conventional assignment next year. So I went to Long Island City, and now this is around 2013, and I tried a couple of cases, and I soon realized something I didn't know as a newbie. I realized what was the real downside of a bullet part in matrimonial law. And it was this: the other 3 judges in the conventional parts, whenever they had a difficult or undesirable or intractable case, they would say, okay, that's it, you're going to trial, and they would send them to Long Island City, to my part, to be tried. So in essence, it was a dumping ground for all the tough cases. And I got it. And it was too late. Now I'm there, and I'm getting these cases, but I can handle it. And I was getting paid, and that's my initiation, and that's what I have to do to gain some seniority. So be it. I made a deal, and that was it. 3 or 4 months passed by in the matrimonial part, and a case shows up that's assigned to me for a hearing. Now, a hearing, as opposed to a trial, is sort of a mini trial. It's maybe on one issue. Something arises. An issue arises, and it has to be tried, and evidence has to be submitted, and you have testimony and witnesses and lawyers' arguments, et cetera, et cetera. It's just like a trial, but it's abbreviated because it's only on one issue. In this particular matter, it was for a downward modification of child support. And under New York law, in matrimonial cases, 2 things are always open for discussion and modification. One of them is child custody, and the other one is support. And the reason being very simple. A parent who is given custody of a child might be the proper custodial parent and the best one for the interest of the child. It's all about the interest of the child. That's the first and foremost consideration in matrimonial parts. And that could change. For instance, a mother could get custody and be a very good mother, and then 2 or 3 years later develops a drug habit or gets arrested or hooks up with some criminal partner or something like that, and now she's undesirable and they want to change custody. So that's always an open matter. Or somebody dies or somebody gets seriously ill, that's more common. And custody is therefore open for change. Of course, you have to prove why a change is necessary. And the other one is child support, and for the same reasons, basically, the same rationale. Financial situations change. A parent can lose a job and become impoverished and not be able to pay, or on the other hand, a parent can become enriched and hit it big in business or something, have a small business that blossoms, and they can afford more money. And so it's always open for upward or downward modification. So in this particular instance, I called the lawyers in. This was for a downward modification, apparently brought by the husband and father. He had 3 kids. He was married to this woman for about 17 years. And the case was about 4 or 5 years old when I got it. It had been decided. She had custody of the kids. They were preteens then, and now they were teenagers. One of them was just going to be a teenager, and the other 2 were in high school. And this guy wanted a downward modification. Well, as is my custom, I called the lawyers in. The 2 lawyers came, and I said, let's have a conference in chambers among ourselves. And there's a couple of reasons for that. First of all, I found out what the issues were. And you can talk informally without being in the courtroom on the record and find out what this case was all about and get to the heart of the matter. You could lay down the rules of procedure and tell the lawyers, just like a referee in a boxing match, you can't do this, you can't do that, or you can do this, I don't mind if you do this, you do that. And you lay out the ground rules for the proceeding. And but basically, it's really so important so that you understand what the real issues are, and you can limit it and get it down to, narrow it down to what really matters, so you don't waste a lot of time. In talking to the 2 lawyers, the husband's attorney, who was the petitioner here and looking for a downward modification, I asked him, I said, well, what's the basis for the downward modification? The guy looked at me with a blank look. I said, what's the problem? He said, Judge, he said, I'll tell you the truth. I'm not in support of this thing. This guy is insisting that I represent him, and I will, but I don't think there's a lot of merit to it. Apparently, he said, this guy has remarried, and the impetus for this hearing is probably the new wife who says, why are you paying all this money for those kids? We need the money. Go get a downward modification. And this guy's insistent, and he's giving me a hard time. And I told him, I don't think you're going to get it. I don't think there's any reason here. You have the same job. Everything else is all the same. The situation's not any different. And I don't think you're going to get it. And he said, but he's insistent. And apparently he's insistent because he's being pressured by the new wife. And it's against my wishes. I said, okay. I said, what about the wife here with the custody, the original wife with the 3 teenagers? Does she want a modification? And our lawyer said she would like a modification, but she's not asking for one, Judge. She knows this guy, the ex-husband, is still working the same 2 jobs he always worked during their marriage. One is driving a tow truck, and the second job is driving a limousine for a car service. She knows what he makes, and he may make a few bucks more now because rates have gone up and people are using these services more and more. But she doesn't want to ask for too much because, as I told her, and she understands, you can't get blood from a stone. If you go too far and try and get an upward modification, even if you're entitled to it, you might discourage civil disobedience and noncompliance from the party who has to pay. And it's not a good idea. So she's being reasonable. She doesn't want anything, even though the kids have higher expenses and the needs are greater. But she's been happy. The guy's been paying on time, and he has met his obligations. So she's being reasonable. I said, okay, that's good news. Somebody's reasonable here, and the other guy is being unreasonable. I said, so how about, with your consent of both of you guys, I bring the petitioner, the husband, in here for a discussion with me, with his lawyer present. but I need your consent. And both of them consented right away. I said, this way we'll cut to the chase, and maybe I can talk to this guy and talk him out of this thing in private. They said, no, it's worth the chance. Why not? We don't want to go through a whole hearing and get involved and get tied up in the courthouse maybe for a couple of days. Sure. I said, okay. So I excused the wife's lawyer. I said, and I sent the other guy out, the husband's lawyer, to get his client and come back, which he did. And he introduced him and he sat down. And I spoke to him, and I think we'll use his name, Ahmed. He was from Pakistan. And I said, okay, Mr. Ahmed, what's the problem here? Oh, I pay too much money for my children. I want to pay less money. I don't make money. I want to pay less money. I pay too much. I want you to make my money less for the children. I said, really? I said, okay. Are you still driving the tow truck? Yes, Judge. I said, are you still driving the limousine when you're not driving the tow truck? Yes, Judge. I said, and it's the same job you had when you were married and to this first wife? Yes, Judge. I said, so you're making the same kind of money? Well, no, business is bad. It's not so good. We're not making the same kind of money. I said, okay, prices have gone up. I didn't hear that use went down for tow trucks. And I didn't hear, if anything, the car services are doing more business than ever. I said, but you say you're not making any money. What proof do you have? Oh, I'm just telling you I'm not making enough money. I need to have my money reduced. I can't pay for these children anymore. I said, you realize that the kids, their expenses now that they're teenagers are higher. No. I don't care. I'm not making money. I'm not making enough money. And he was just adamant and insistent. I said, okay, you can leave. And I spoke to his lawyer. I excused the husband, and he went back to the courtroom, sat in the courtroom. And I spoke to the lawyer. I said, look, talk to this guy. He's going to lose. He has no proof. This is just his desire to pay less money because his new wife wants him to pay less money. There's no basis for this. There's no substance to this thing. He's going to lose. And we're going to waste time trying this thing or hearing this case for how long it takes and waste taxpayer money and the court resources and my time and your time. But this guy was going nowhere fast. He's spinning his wheels. There's no real proof here, unless there's something I don't know. He says, no, Judge, that's the whole story. You got it all. He says, and I agree with you. He said, I don't even want to do this. I'm not here to sell you something that, on false pretenses. He says, I agree. I said, okay, go out and talk to this guy now that I spoke to him and come back and tell me what he says. So he goes out. 2 minutes later, he comes back. He says, Judge, bad news. He wants to go ahead with the hearing. He's not listening to you. He doesn't want to hear this. And I guess he says, I imagine that's the wife's pressure, the new wife, I said, okay. I said, I'll tell you what. Now both lawyers were in there for this conference. I said, tell you what, it's worth it. Let me take one more shot at this guy, at talking to him. Bring him back. You come back with him and the wife's lawyer. I said, you're excused. Let him come back with his lawyer, and let me take one more shot at him. Maybe I can solve this thing. They said, anything you want to try, Judge. If you think it's worth it, why not? Okay. I says, yeah, this will take a couple of minutes. So they both leave, and the husband's lawyer comes back and enters the chambers, knock on the door, and he brings the husband again. Now I'm wearing my robe. And I'm wearing the robe for this conference for a couple of reasons. First of all, the robe scares them, and it conveys authority. And people see a robe and then they start to get shook up because now they're confronting authority. Now we're getting formal. Plus, it conveys a sense of urgency and immediacy in the situation because now he knows that the robe, right after this, I'm getting ready to go in the courtroom and start the proceeding here, start this hearing, and he's going to be put to his proof. Okay. So he sits down, the lawyer sits down, and I said, let me understand. Mr. Ahmed, what's the problem here? You want to pay less money, right? You don't want to pay so much child support. That's right, Judge. I can't pay. I have money. He starts the song and dance again. I said, no, wait a minute. I have to tell you, this is your lucky day. You have come to the right place. Really? I says, really? I says, you don't want to pay child support as much as you pay. You want a reduction. Forget reduction. I'm going to give you no child support, okay? You don't have to support the children, no child support. We're going to cancel the old order. No problem. Oh, Judge, really? I said, yes. I said, but when you leave here today, you're going to have custody of those 3 teenagers. You're going to take them home with your new wife, who I'm sure is going to love them like her own and raise them like they're her own children. And I'm sure the kids are going to love her. And you're going to take them home. And you're going to save a lot of money, because all the money you're wasting on child support for food, clothing, drugs, tuition, transportation, you're going to do it for less because they're going to live with you. And you could save a lot of money. No problem. Your troubles are over. You go out now and you wait. In 5 minutes, I'm going to write and sign off a decision. No more child support for you. Now he looks at me. Now he's deflated. And he looks at me, but he's not done bargaining yet. Well, Judge, he said, if you do that, you will force me to move back to Pakistan. I said, that's okay. If you want to move back to Pakistan, be my guest. I said, I'll tell you what, you call the car service and call your friends, come and tell them to pick you up here and take you right to the airport to go to Pakistan with your new wife. I'm sure she's going to love Pakistan, because I understand it's very friendly to women in Pakistan. She's going to love the new atmosphere in Pakistan. It's going to be great. And I'm sure Pakistan is a wonderful place, because 20 years ago, you left Pakistan to come here. It must be a terrific place. That's why you left. So you go to Pakistan. I give you 6 months in Pakistan, the most, before you come back. And when you come back, you're going to owe all the child support that you didn't pay, plus interest. And if you don't pay it all at once in one day, I'm putting you in jail for contempt of court. And you're going to be paying, if you're going to stay in jail, you stay in jail as long as you want. And when you get out, you're going to owe that money plus the interest. You're going to be paying child support after these kids are grown-ups, because you're going to owe your wife that money. All right? So be my guest. Go out and sit there, and I'll be right out, and I'm going to sign the order for you. So he leaves. He's all shook up now, and his lawyer walks out. 2 minutes later, the lawyer knocks on the door. Big smile on his face. He says, Judge, case is over. We're going to withdraw the petition. Call the stenographer. We're going to put this on the record. I says, I'm glad he saw the light. He said, yeah, I'm glad he saw the light too. He said, no problem now. He's going to pay the child support the same way, no more modification. And so all I have to say is, in this particular instance, I gave the husband, who was very difficult and adamantly refusing his lawyer's advice and my advice, I gave him exactly what he wanted. But, like the movie, you want the truth, you can't handle the truth. Well, he couldn't handle the facts. Thanks for listening. Come back next week for another episode of Uncommon Law, lessons they don't teach in law school. I'm Judge Rudy Greco. Court is adjourned.